Yes, like Tom, I'm also a partner in a multinational law firm based in Washington, D.C., Arnold & Porter, Kaye, Scholer, and it is a real pleasure to be here. Thank you so much for the invitation, and it's also a real pleasure to sit, as Tom's already said, in an audience that doesn't include 100 lawyers, which is normally the conferences we get invited to. So, so this is great. Thanks very much. I am going to address the subject of cooperation in corporate investigations. And I think that most of you will know this, but I want to make clear at the outset that we're not talking about cooperation in the normal sense of the word, whereas we're all cooperating together to have a successful conference this week. This term is a term of art in the United States with respect to cooperation with the government, and specifically with the US government, although it's broader than that and becoming increasingly so. But cooperation with the government to help the US government investigate and prosecute wrongdoing and criminal conduct. So that's the form of cooperation I'm talking about. Tom mentioned the term snitching. People also say ratting. Those terms reflect the less positive aspects of cooperation, but I see it in this context as not uniquely good, but mostly a good force in providing incentives for people to cooperate, to disclose wrongdoing, and to provide the government with information the government needs in order to enforce the laws. So that's basically my take. In thinking about how to talk about this subject in front of an audience that is mostly non-US, I thought that this really is, I think, an unusual phenomenon in US investigations and prosecutions. And there are a number of reasons for that. And as I was reflecting on that, I thought that those have to do both with our laws and the way those laws are different from those of other countries, but also a lot to do with our history. So I'm going to start my presentation by focusing on the history of how cooperation really developed in our system as a tool for government investigators and prosecutors, and then also talk about the legal framework for how it works in practice. There we go. Okay. So this slide is really just a guide to how I'm going to proceed, talking about the incentives that have been provided for individuals to cooperate, the historical background and how that's evolved and been used first in the Mafia situation, and then later on in organized crime more broadly, and then more recently in the corporate context, and then talk about, again, some of the laws governing cooperation in the US system. One of the ways to start this is really to talk about how cooperation is indeed a very critical element of the US system. And why is that, I think, is explained partly by our history. And what does it mean for corruption and the anti-corruption efforts? And then lastly, what does this mean? What do you need to know about it? So cooperation does have its roots in anti-mafia enforcement in the United States, and we heard a lot about the Mafia yesterday, and those presentations were excellent. I'm not going to go into the history of the Mafia in the US. I did want to just explain a little bit about how cooperation was so important in this context. And my picture of Sammy the Bull here, Pedro Reski referred yesterday to some of the coverage of the Mafia as potato chips for the public. And I feel a little bit guilty here because this is definitely potato chips. This is just sort of a way to wake everybody up and show a real mafioso who is almost a stereotype. He looks like it's out of a movie, not really out of a real US courtroom. But Sammy the Bull Gravano was a witness, a very important witness against other Mafia figures. He was involved, he admitted to being involved in 19 murders, and when he was given a guilty plea by the federal government in his case, he received only a 5-year sentence, which a 5-year sentence is quite low in the United States even for one more murder, let alone 19. So this was a very significant reward for his cooperation. And I think that our history explains that. The Mafia was a very significant problem in the United States in the 50s, 60s, 70s, and even into the 80s. And for the Justice Department, it was a real problem. The Mafia had a real stranglehold on certain communities in New York, New Jersey, and elsewhere, and the government needed to find a way to really break the omerta, the oath of loyalty that Mafia family members took, and break this stranglehold and really in order to address this serious criminal problem and the violence that surrounded it. So these extreme rewards, as Sammy the Bull Gravano received and other Mafia figures received, were a part of how the government was in fact able to break the Mafia. And there is still Mafia in the United States, as those of you who watch The Sopranos may know, but it's nothing like it was 50 years ago when it was a real problem. So this helped the government successfully combat this very significant crime problem. And another important factor to note is that the person who came into the government or who agreed to the government's request to cooperate is the person who gets the reward. So the government's able to provide an incentive to the person who breaks first. First in, you get the benefit. The use of cooperation in our system really, in the Mafia cases, are only a minority of the cases in which cooperation has been used. I myself was an organized crime prosecutor for many years in the District of Columbia, so that picture, which I had no idea would be so big when I put it in this slide presentation, but that's actually me a long time ago, 15 years ago, in a big drug gang case in Washington, D.C. Anyone who grew up in Washington, D.C. when I did would recognize the witness here as the most notorious drug dealer in Washington, D.C.'s history, Rayful Edmond. And he was convicted of RICO racketeering activity for his involvement and his leadership in the big drug gang that he was the head of back in the 80s. And then he ultimately cooperated against others. No one was going to give him the direct benefit of cooperating, but interestingly, he was approached because he had other family members who had gone to jail as part of his case, and he agreed to cooperate in order to get his mother and his sister out of jail, which they have long since been released. So he is still in prison, but did cooperate in order to help benefit his family members, which I think was a sort of a creative use of his cooperation, really in order to use his testimony to help convict other people who sold drugs with him. So this is just an example of how cooperation evolved in the U.S. system. There are far, far more cooperators in the drug and crime context than there ever were in the Mafia context. So it became very commonly used in our system, again, to help break street crime. And then really to get to the point of this conference, I want to move to talking about cooperation in corporate crime and really how the U.S. authorities have used the same principles that provided incentives for cooperating in the Mafia and drug and gang context to the corporate context. And some of you may recognize, there we go. This photograph is from the Enron prosecution, and this is a man named Andrew Fastow, who was the chief financial officer of a company called Enron. And some of you will remember that name from the Enron task force that prosecuted a number of senior leaders of that company about 10 years ago. This is Andrew Fastow on the stand, and Jeffrey Skilling and Ken Lay were the executives who were convicted as part of the cases against this company. The Enron case, I think, is unusual because cooperation in the corporate context, I think, is fundamentally different from cooperation in the other context that I was talking about in a significant way, and that is that corporations really tend to serve a good social purpose. And the corporations, for example, that were on Tom's slide indicating, which companies have had resolutions with the Justice Department and the SEC in the last few years, those companies are producing goods that people want. And providing services to consumers and to the public. And so overall, the identity of the corporation is not, a mafia gang or a drug gang that really exists to commit crime, but it's a corporation that is trying to serve the public and be a responsible player in society. So I think the context is different. Enron, maybe not. Enron, as far as I can tell, was really set up to maybe it had a legitimate purpose at the outset, but it became an instrument for fraud in a way that I think is fundamentally different from most companies. But to go back to the example of Andrew Fastow, he had a lot of information as the chief financial officer about how the company operated, and there was a significant amount of evidence in that case, apart from Andrew Fastow, because the government had a lot of email evidence and mountains of information about how the company had committed fraud and been poorly governed, to say the least. But Andrew Fastow was the person who took the stand and was able to explain in person sort of how it happened, how they decided to operate this way and how they actually operated. And so that was a very important way to help bring down the leaders of Enron. Now to get a little more technical and somewhat less interesting, just to go to the legal framework. And I want to start by talking about individuals and then move to the legal framework that governs corporate cooperation. The U.S. sentencing guidelines did establish mechanism for rewarding cooperation. And that mechanism, you may have heard the term 5K motion or 5K letter. And that 5K is the provision of the sentencing guidelines that allows a judge to depart from the sentencing guidelines, which are otherwise fairly rigid prescription on, what sentence a crime warrants based on the type of crime, the level of crime, the amount of money involved, if it's a financial crime, and other factors. Those guidelines used to be binding. They no longer are binding, but many judges do still follow them, and so it is a significant benefit to an individual who's charged with a crime to be able to receive a 5K letter that allows the judge to depart from the guidelines in imposing a sentence. And if the motion has to start with the prosecutor, so a person is not entitled to this benefit unless the prosecutor files this motion, so it's within the control of the prosecutor, not the judge initially. But then once the motion is filed, the judge has absolute authority to depart from the guidelines to any level, to any extent. So then the sentencing discretion moves entirely to the court. So what is the incentive for cooperation in the corporate context? It's fairly clear from what I've explained how it's a significant incentive in the context of an individual who's facing a sentence. The incentives for corporations, I think, are somewhat more complicated, but the incentive for the government is certainly the same. The government wants to encourage companies to report violations so that the government can take the appropriate enforcement action, and really to provide incentives for companies to police themselves. So the framework has evolved in order to make cooperation, in order to provide incentives for corporations as well as individuals. And we see this in the principles of federal prosecution of business organizations, which are in the U.S. Attorney's Manual. And these principles were adopted back in 1999, sort of as corporate prosecutions had been on the rise for at least a decade or so. And the Justice Department decided that there should be a more rigid framework for evaluating cooperation. So these principles were initiated in 1999, and they've been revised over time, really in response to various criticism from either the defense bar or the ABA, the American Bar Association, or the courts, or even the public and the media. And so there have been a number of iterations, and you'll hear people, U.S. lawyers, refer to the memoranda that the Justice Department has issued over time. And some of you who study this may have access to some of this literature, but there's a ton of literature in the U.S. legal press about these memoranda. But essentially, they just have evolved the way that these principles have been applied in the corporate context. And I'm not going to go through each of these memoranda, but these memoranda again, having been issued over time, are what I'm talking about. Some of you may have heard of the Yates Memorandum, which was the most recent of these, and I'm going to get back to that in a few minutes, but that one was named for Sally Yates, the recent Deputy Attorney General, and issued in 2015. And they're really, I think the principles have been essentially the same, but modified in certain respects over time. The principles, though, if you're not already familiar with this subject and you want to understand where do I look this up and how do I come back to this after this presentation and after this conference? If you write down only one thing, the U.S. Attorney's Manual, USAM stands for U.S. Attorney's Manual. This is the manual for federal prosecutors. It's available online at the U.S. Justice Department website, and it provides guidelines for all sorts of types of crime, but this is one of the probably most widely cited and evaluated provisions, and this is the factors to be considered by prosecutors when they decide whether to proceed with a criminal prosecution of a corporation or what type of agreement to allow as a resolution of a particular violation. And this goes to the question that was asked earlier of, is there a formula for these resolutions? And there's really not. This is the closest thing that we have to a formula in connection with the sentencing guidelines, which prescribe certain sentences, but these factors you'll see are fairly flexible, but these are the factors that prosecutors are supposed to consider. And the ones that go to the company's cooperation I've highlighted in red so that you'll see those and that they'll stand out. Obviously, the corporation's willingness to cooperate, the corporation's timely and voluntary disclosure of wrongdoing, and both of those are very specific and important words. Timely is one that I think can hardly be overstated. When we're advising companies what to do about a problem, we'll have to consider lots of factors in order to determine whether to advise a company to self-disclose or to make a voluntary disclosure, to use another term. But making that disclosure, if it is the right thing to do in the company's best interest, making that disclosure in a timely manner to get credit for it is very important. And that's so that the company gets into the government ahead of, say, a whistleblower or someone else who might report wrongdoing. So if a company finds out about conduct that truly is wrongdoing, there's a very strong incentive to go in and report that to the government as quickly as possible. The other factors relating to cooperation include the company's remedial actions, steps taken to address the problem, and then the adequacy of the prosecution of individuals. So, and that's not just, can individuals be prosecuted and does that satisfy the need for enforcement, but also is this the work of individuals who are bad actors within a company, or is this the work of individuals who are actually carrying out what was tacit company policy? So is this a corporate problem, something the company needs to address, or is it really the result of certain individuals who went astray and did wrong without wide knowledge of the conduct within the company? The other factors here are also important, and also important for companies to understand as a matter of designing compliance programs going forward. Every company needs to look at these factors in order to evaluate its own compliance processes and the training and the ethos that the company is promoting for its individual employees to ensure that the company has the kind of culture that it wants to avoid these kinds of problems. So when I talk about the race to the government, that relates to this sort of incentive to disclose in a timely manner. The individuals in our gang cases, they didn't typically come forward. They were typically set up by the police in order to get cooperators at a lower level, and then the lower level people who came in would get credit. But within a corporate context, there are incentives to go to the government, and Tom just gave a very sort of different tale about how these whistleblower programs work in certain cases, and I don't disagree with that. I think sometimes a lot of whistleblowers are motivated by the money and not in order to try to clean up the company. But there are occasions when these whistleblower awards do actually result in somebody reporting something that that should be addressed, an enforcement action that should be taken. Companies also now have ethics incentives so that employees who provide even sometimes anonymous tips can be rewarded for providing information that leads to a company's ability to address a problem within the company. And then obviously, as I've discussed, leniency in criminal prosecution. Companies also have these incentives with respect to one another. So we've seen this in certain corporate contexts where a supplier may grow to understand that there is a problem either with bribery or some other type of offense. This is in the wake of the Volkswagen problems. This is now happening to some extent with environmental compliance. You'll see that companies are deciding, okay, we don't want to be prosecuted for this after some other company reports what's going on, so we're going to go talk to the government and give them everything so that we at least get credit for that. And recent guidance actually requires companies to provide information about the wrongdoing of employees. This is, to get back to the Yates Memorandum, the purpose of Sally Yates's memorandum was to address criticism that the Department of Justice received about the failure of the Department of Justice to prosecute individuals for crimes in connection with the financial collapse in several years ago, or in 2008, I guess now. So the Department of Justice is now specifically rewarding companies for providing information about individuals and in fact requiring that in order for a company to get credit for cooperation, it has to provide that information about individual employees. And this causes some difficulty for companies in a number of ways that we can talk about. But generally, I think that this whole framework, both for individuals and in the corporate context, for providing incentives for cooperation, this does allow U.S. investigators and prosecutors to provide incentives to get information early that enables prosecutors to bring charges early and build cases where I think without these incentives, it would take much longer to build cases because the government would not have timely and direct information on criminal activity that it needs to move forward with enforcement action. Good, okay, I'm almost done. So the Yates Memorandum I just mentioned briefly was released in 2015, again prompted largely by concerns about the lack of individual accountability after the financial crisis. In addition to the greater emphasis on individual accountability, it also requires coordination between civil and criminal attorneys at the Department of Justice so that civil resolutions can be pursued as an alternative to criminal when that is appropriate. Then finally, this is really addressing individual accountability for corporate misconduct, and this is just out of the Yates Memorandum. This is what specific factors the government is going to look at when it evaluates how well a company is cooperating and whether the company really is providing adequate information about individual culpability. So, as I said before, to be eligible for credit, the company has to provide DOJ with all information. Corporate investigations, like Tom was talking about before, when law firms go in to conduct these investigations, law firms need to keep this in mind too, but DOJ requires that its investigations focus on individuals from the beginning, and so I think part of the problem in the financial crisis was there was a perception that the companies resolved matters and the government never really bothered to go after the individuals once they got the big fines. So that's no longer tolerated. I'm not sure it ever was, but that's part of what the memorandum was aiming to address. And then it's also a requirement that prosecutors not be allowed to address and to reach a resolution with the company until the individual cases are resolved. So some of the issues that this raises, and then this is a good time to turn to questions because I think there will be questions in some areas. We talked about loyalty and the presentation before about the firefighters' ethos, I think, goes to this. Good organizations actually do breed loyalty, and sometimes individuals are not really willing to provide information about wrongdoing within their company because they're treated well, they're loyal to the company. And overall, I think that's a good thing. We want individuals to be loyal. We want companies to treat their individuals well. That helps make for a happy society. But obviously, you don't want that incentive to override an individual's incentive to cooperate when there really is wrongdoing that it's in society's interest to eradicate. So loyalty and culture, I think, cut both ways in this area in ways that are interesting, and we had a whole presentation on this because I think it really is a very interesting and complicated topic. I think the same as individuals not wanting to talk about their companies, companies often, and I see this a lot in the companies that I represent, I think that this is good. Companies feel like, you know, we may have done something wrong. We didn't realize that the government would view this as illegal, and we think that it's unfair to blame employees for this because this was company policy. There were no bad actors here. And I think that, too, is often true, and I see that with some of the companies that I represent, that they often don't want to provide information. So it's very tricky to advise companies about how to handle this when you're really also trying to advise the company to do the right thing by its employees. So you have to really ferret out, was the conduct criminal? Did the employee know that it was criminal? And if that's the case, then obviously you do have to disclose. But there are cases where the government investigates and, you know, again, there may be violations of the law that individual actors didn't realize were criminal. And so I think this is an area where you have to think very carefully. So how does a company know when a complaint is serious, whether it comes from a whistleblower or from a government inquiry or somewhere else? How does a company know when a complaint is serious or when it's motivated by bias or self-interest, like the whistleblower complaints that Tom was talking about? So just a couple things. A thorough investigation of the issues is obviously critical. So bring in someone who can investigate and advise the company on how to deal with this in the best way. Knowing how to interact with the government is also very critical. I was a prosecutor for a number of years at the Department of Justice before joining the law firm several years ago, and that's part of what I think I can help with is I know a lot of the prosecutors who are still at the Department of Justice. I understand how they think because I was in their shoes once, and so I think that that's very helpful. Know how to interact with the government and when to share information, how much information to share, and how to do it, I think is very important. And then careful handling of employees. I think a lot of the problems I see are as much human relations or HR problems as they are criminal activity in many cases. So you get whistleblowers when you get people who are disgruntled. It's not just the financial rewards, but sometimes you'll have someone who is about to be fired who then goes and writes up a whistleblower complaint because that then is a way for them to get fired and get some money out of it. And so that's obviously a negative motivation, but I think sometimes problems can be avoided. If an employee reports something and the employee is mistreated, that employee is much more likely to become a whistleblower. The employee reports something and is listened to and rewarded and treated properly. So HR is really a significant aspect of all of these cases. So those are the issues that I had identified, and I think if we're ready for questions, I can take questions. So.
Thank you very, very much for your very dense and powerful talk.